making that other state a surrogate home. The bar is very high for general jurisdiction based on contacts alone.
So minimum contacts, purposeful availment leading to specific or general jurisdiction, is the first hurdle. What about the second part, fair play and substantial justice?
Yes, once minimum contacts are found, the court must also determine if exercising jurisdiction would be fair and reasonable. Would it comport with fair play and substantial justice? Here, courts weigh several fairness factors. The burden on the defendant of litigating in the forum state's interest in adjudicating the dispute, for example, protecting its citizens, the plaintiff's interest in obtaining convenient and effective relief, the interstate judicial system's interest in obtaining the most efficient resolution, and the shared interests of the several states in furthering fundamental substantive social policies. Even if minimum contacts exist, in rare cases, the fairness factors might weigh so heavily against jurisdiction that a court declines to exercise it. But usually, if minimum contacts are strong, it's likely considered fair.
Are there other ways a federal court specifically might get personal jurisdiction beyond just borrowing the state's long-arm statute?
Yes. Federal Rule of Civil Procedure 4K provides some alternative sources for personal jurisdiction in federal court. Rule 4K1C allows nationwide jurisdiction when a specific federal statute authorizes it, like the Federal Statutory Interpleader Act we discussed. Rule 4K1, the bulge provision, allows service on certain parties, those added under Rule 14 impleader or Rule 19 required joinder, within 100 miles of the federal courthouse where the suit is pending, even if that's outside the state and state law wouldn't otherwise allow PJ. This helps bring necessary parties into the suit efficiently. And Rule 4K2 is an interesting, unusual provision. It acts as a federal long-arm statute for claims arising under federal law where the defendant is not subject to personal jurisdiction in any state's courts, but has sufficient minimum contacts with the United States as a whole. It's a gap filler to ensure foreign defendants with significant U.S. contacts don't escape federal claims just because their contacts are spread across multiple states rather than concentrated in one.
That bulge provision and the 4K2 sound like important federal wrinkles. You touched on corporations earlier for general jurisdiction being at home. How does specific jurisdiction usually work for them?
For in personam jurisdiction over corporations, specific jurisdiction works much the same way as for individuals did the corporation purposefully avail itself of the forum state in relation to the claim. Did it ship goods there, solicit business there, have employees there related to the lawsuit? If the claim arises from those contacts, specific PJ is likely. General PJ, as we said, is limited to the state of incorporation and principal place of business, absent exceptional circumstances.
And briefly, what about jurisdiction over property itself, in rem, and quasi-in rem?
Right, jurisdiction over things. In rem jurisdiction gives the court authority to determine the rights of all persons in the world regarding a specific piece of property located within the forum state, the example, an action to quiet title. The property must be present, and adequate notice must be given. Quasi-in rem jurisdiction also involves property in the state, but it seeks to determine the rights of only the specific parties to the action regarding that property, type 1, or uses the property as a basis to assert jurisdiction over the defendant on an unrelated claim, but any judgment is limited to the value of the property, type 2. Crucially, after Schaffer v. Heitner, even for these property-based jurisdictions, the defendant whose property rights are at stake must still satisfy the minimum contacts test with the forum state. Just having property there isn't enough on its own anymore.
Okay, so minimum contacts applies broadly now. And underpinning all of this jurisdiction, whether over people or property, you mentioned a fundamental due process requirement that ensures basic fairness, notice, and an opportunity to be heard. It sounds simple, but I imagine there are critical nuances for the bar exam here too.
You're absolutely right. It's foundational, but the details matter. Due process demands that any significant deprivation of life, liberty, or property by adjudication must be preceded by adequate notice and a meaningful opportunity to be heard. The standard for notice, established in Mullane v. Central Hanover Bank and Trust Company, is that it must be reasonably calculated under all the circumstances to apprise interested parties of the pendency of the action and afford them an opportunity to present their objections. It's about reasonableness, not necessarily actual receipt, though the method chosen must be one that is itself reasonably likely to inform the person.
Reasonably calculated. What does that mean for the actual methods used? Can you just publish something in the newspaper?
That's where the nuances come in. When it comes to methods of notice, if the name and address of a party or claimant are known or reasonably ascertainable through diligent efforts, due process requires notice through means that are actually likely to reach them. This typically means personal service or service by registered or certified mail. Notice by publication, like in a newspaper, is generally considered a last resort. It's constitutionally permissible only for parties whose identity or whereabouts cannot be ascertained after diligent effort. You absolutely cannot rely solely on publication if you know who the claimants are and where they live, or could find out with reasonable investigation. You have to use a method more likely to actually inform them. On an exam, always look for whether the party attempting notice made that diligent effort before resorting to publication. If they knew names and addresses and still just published, that notice is likely constitutionally deficient. It's a critical check on fairness.
So we figured out jurisdiction, the power of the court, both over the subject and the parties, and the notice required. Now let's narrow it down. Where specifically, geographically, within that court system can we actually file the case? That sounds like it's about venue, less about power, maybe more about convenience.
Precisely. While jurisdiction is about power, venue is about the proper geographic district within a court system, like a specific federal district court, where a lawsuit can be brought. It's largely a matter of convenience for the parties, witnesses, and the court system itself. And like personal jurisdiction, but unlike subject matter jurisdiction, venue is considered a personal privilege of the defendant and is waivable if not objected to in a timely manner, usually in the first Rule 12 response.
Okay, waivable like PJ. So what are the rules for figuring out the right venue in federal court?
The general venue statute for federal civil actions, 28 U.S.C. Section 1391, provides three main options for where venue is proper. First, in a judicial district where any defendant resides, if all defendants reside in the same state. Second, in a judicial district where a substantial part of the events or omissions giving rise to the claim occurred, or where a substantial part of the property that is the subject of the action is situated. This is often the most relevant basis. Third, if venue cannot be established under either of the first two options, which is rare, there's a fallback provision. Venue is proper in any judicial district where any defendant is subject to personal jurisdiction with respect to the action.
Resides sounds simple, but how is residency determined for venue, especially for companies? Is it the same as citizenship for diversity?
Good question. It's slightly different, which is important to track. For residency, for venue purposes, an individual, including a lawful permanent resident alien, resides in the federal judicial district where they are domiciled. A business entity, corporation, partnership, etc., whether a plaintiff or defendant, is deemed to reside in any judicial district where it is subject to the court's personal jurisdiction with respect to the civil action in question. If the entity is a defendant, this means any district where it would have sufficient contacts for PJ. If it's a plaintiff, it resides only in the district where it maintains its principal place of business. Notice the difference. For diversity citizenship, an unincorporated association has the citizenship of all its members. But for venue residency, we look at where the entity itself is subject to personal jurisdiction. That's a key distinction to keep straight.
Okay, different residency rules.
Yeah.
What if the plaintiff files in the wrong venue, or even if it's technically correct but super inconvenient?
That leads to change of venue. If the original venue is improper, the court, upon timely motion, must either dismiss the case or, if it's in the interest of justice, transfer the case to a federal district where it could have been brought initially, i.e., a district with proper venue and PJ. That's Section 1406. Even if the original venue is proper, a court can still transfer the case under Section 1404A for the convenience of parties and witnesses and in the interest of justice to another federal district where the action might have been brought or to which all parties have consented. This is about moving from one proper venue to a more convenient proper venue within the federal system. There is also the related common law doctrine of forum nonconvenience. This applies when the court finds that the lawsuit would be much more convenient and appropriate in a different court system, altogether typically a state court or a court in a foreign country. If this doctrine applies, the federal court doesn't transfer. It dismisses the case, usually on the condition that the defendant agrees to submit to jurisdiction in the alternative form and waive any statute of limitations defenses that might have arisen. It's a discretionary dismissal based on extreme inconvenience.
And when a case gets transferred, does the law travel with it?
That depends. Under the Van Dusen rule, if a case is transferred under Section 1404 from a proper venue to another proper venue for convenience, the receiving transferee court must apply the same choice of law rules that the original transferor court would have applied. The law follows the case. However, if the case is transferred under Section 1406 because the original venue was improper, the transferee court generally applies its own choice of law rules, as if the case had been filed there originally.
Speaking of choice of law rules, that brings us right back to that tricky area, the Erie Doctrine. You mentioned it determines whether a federal court uses state or federal law. This feels like a major headache zone for bar prep.
It absolutely can be, but breaking it down systematically helps. You're right. The Erie Doctrine governs the choice between state and federal law when a federal court is hearing a case, most commonly one based on diversity jurisdiction, though it applies to supplemental state law claims, too. Just to be clear again on terminology, conflict of laws usually refers to state court rules for choosing which state's law applies when multiple states are involved. Erie is about a federal court deciding whether to apply state law or federal law to a specific issue in the case before it.
Okay, federal court deciding state versus federal law. What's the basic rule?
The starting point, from Erie Railroad v. Tompkins, is that in diversity cases, federal courts must apply state law on matters of substantive law, but they apply federal law on matters of procedure. The idea is that the outcome of the case shouldn't be drastically different just because the plaintiff chose federal court instead of state court based on diversity. Federal courts shouldn't create their own general federal common law for substantive issues governed by state law.
Substance versus procedure. That sounds like the million-dollar question. How do you figure out which is which? That seems like the core challenge.
That is the core challenge, and the analysis has evolved. Here's the modern approach, often called the HANA analysis, which you should use on an exam. Step 1. Is there a valid federal law directly on point? Look for a Federal Rule of Civil Procedure, FRCP, a federal statute, or even a constitutional provision that directly governs the issue. If yes, you then ask if the federal law is valid. If it's an FRCP, it's valid if it regulates procedure and doesn't abridge, enlarge, or modify any substantive right per the Rules Enabling Act. FRCPs are almost always found valid under this test. If it's a federal statute, it's valid if it's arguably procedural and constitutionally sound. If the federal law is valid and on point, you apply the federal law. This is the HANA prong.
Okay, so if there's a relevant FRCP, apply the FRCP. What if there isn't a specific federal rule or statute covering the issue?
If and no. Then you move to the traditional Erie analysis, sometimes called the Rules of Decision Act prong. Here, you need to determine if the state law rule is substantive or procedural for Erie purposes. The analysis involves several factors. 1. Outcome determinative test. Would applying federal law instead of state law significantly affect the outcome of the litigation? If yes, that weighs in favor of applying state law to prevent forum shopping and inequitable administration of the laws. 2. Balance of interests. Does the state have a strong interest in having its rule applied versus any countervailing federal interest in applying a uniform federal practice? 3. Avoid forum shopping. Would ignoring the state rule lead litigants to flock to federal court just to take advantage of a different federal rule? If, after considering these factors, the state rule looks more substantive, meaning it strongly affects outcomes or reflects significant state policy, the federal court should apply the state law. Common examples of issues usually governed by state law under Erie include the elements of a claim or defense, statutes of limitations, tolling rules, burdens of proof, and choice of law rules themselves. Issues typically deemed procedural and governed by federal law include things like rules about jury-judge allocation, admissibility of evidence in federal court, though state privilege law applies in diversity cases, and court procedures like filing deadlines, unless state deadline is tied to statute of limitations.
That's a complex analysis. So if the court decides it should apply state law, how does it figure out which state's law?
Great question. Under the Claxon rule, a federal court sitting in diversity must apply the conflict of laws rules of the state in which it is physically located. So, the federal court in New York hearing a diversity case first looks to New York's choice of law rules to determine whether New York, or maybe Pennsylvania, or some other state's substantive law should govern the actual dispute.
Okay, Erie is definitely something requiring careful, step-by-step analysis. With the jurisdictional and choice of law groundwork laid, let's turn to the actual paperwork that gets a lawsuit started and defines the issues. Pleadings.
Right. Pleadings are the formal written documents filed with the court that state the parties' claims and defenses. The basic pleadings timeline usually starts with the plaintiff filing a complaint. Then the plaintiff must arrange for service of process, delivering the complaint and a summons to the defendant. The defendant then responds, usually by filing either a pre-answer motion, like a motion to dismiss, or an answer. In some cases, the plaintiff might then file a reply to the answer, but only if ordered by the court or if the answer contains a counterclaim.
Let's talk about service of process first. Getting that initial notice right seems critical.
It absolutely is. Due process requires it. Under the federal rules, Rule 4, the plaintiff is responsible for serving the summons and complaint on the defendant, generally within 90 days after the complaint is filed. If not served within 90 days, the court might dismiss the case without prejudice unless the plaintiff shows good cause for the delay. As for methods of service on an individual within the U.S., Rule 4 allows several options. 1. Following the rules for service of the state where the federal court sits. 2. Following the rules for service of the state where service is actually made. 3. Personal delivery directly to the individual. 4. Leaving copies at the individual's dwelling or usual place of abode with someone of suitable age and discretion who resides there. 5. Delivering copies to an agent authorized by appointment or by law to receive service. There are specific rules for serving infants, incompetents, corporations, officer or managing general agent or authorized agent, partnerships, and non-resident motorists, often through a state official. And remember our discussion on notice for in rem quasi and rem actions. Diligent effort to locate known claimants is required, and personal service or mail is needed if they are found. Publication is only okay for the unknown or unlocatable.
Can defendants just agree to be served or avoid the formal process?
Yes, that's the waiver of service provision under Rule 4D. The plaintiff can mail the defendant the complaint, a notice of the lawsuit, and a request that the defendant waive formal service, along with a prepaid means to return the waiver form. The main incentive for the defendant to waive service is that they get more time to answer the complaint, typically 60 days after the request was sent, or 90 days if outside the U.S., instead of the usual 21 days after being formally served. It's important not to confuse this request for waiver, which is sent by mail, with actual service by mail. Formal service by mail on individuals is generally not allowed under the federal rules unless state law permits it or the defendant agrees to it via waiver.
Okay, waiver gives more time to answer. Before we get to the complaint itself, you mentioned provisional remedies like injunctions. Sometimes action is needed fast, right?
Exactly. Sometimes a party needs immediate court intervention to prevent harm before the case is fully decided. The main ones are temporary restraining order, TRO. This is very short-term relief under Rule 65B, usually can't exceed 14 days, extendable once for another 14 days for good cause or by consent. Designed to preserve the status quo until a hearing for a preliminary injunction can be held. A TRO can sometimes be issued ex parte, without notice to the other side. Only if the moving party shows immediate and irreparable injury will result before the adverse party can be heard, and certifies in writing the efforts made to give notice and why it shouldn't be required. If granted ex parte, the hearing for a preliminary injunction must be set at the earliest possible time. TROs are generally not immediately appealable. Preliminary injunction. This is granted after notice and a hearing, and it maintains the status quo during the pendency of the lawsuit until a final judgment. To get one, the movement typically must show 1. They are likely to succeed on the merits. 2. They are likely to suffer irreparable harm in the absence of relief. 3. The balance of equities tips in their favor. And 4. An injunction is in the public interest. It's a significant remedy requiring a strong showing. It is immediately appealable, permanent injunction. This is issued after the trial, as part of the final judgment, if the plaintiff proves actual success on the merits and meets the other requirements similar to a preliminary injunction. It continues indefinitely unless modified or dissolved.
Got it. TROs are fast and short, prelims last through the case, permanents are final. Now, the complaint itself, what needs to be in it?
The complaint is the plaintiff's initial pleading that starts the lawsuit. Under Federal Rule 8A, it needs 3 main things. 1. A short and plain statement of the grounds for the court's subject matter jurisdiction. 2. A short and plain statement of the claim showing that the pleader is entitled to relief. This is where the Twombly-Iqbal plausibility standard comes in. The complaint must contain enough factual matter, accepted as true, to state a claim to relief that is plausible on its face, not merely conceivable or speculative. 3. A demand for the relief sought, e.g. damages, injunction. Note that certain claims, like fraud or mistake, Rule 9b, and claims for special damages, damages not typically expected from the wrong alleged, must be pleaded with particularity, meaning more specific factual details required than for other claims.
Plausibility standard, not just notice. Okay. What can the defendant do once they receive the complaint?
The defendant must respond, typically within 21 days after being served, or longer if service was waived. They have 2 main options for their first response. File a pre-answer motion under Rule 12 or file an answer. Rule 12b. Motions are crucial. These are defenses that can be raised by motion before filing an answer. The key ones are 1. Lack of SMJ, 2. Lack of PJ, 3. Improper venue, 4. Insufficient process, problem with the summons itself, 5. Insufficient service of process, problem with how the summons complaint were delivered, 6. Failure to state a claim upon which relief can be granted, testing legal sufficiency under Twombly-Iqbal, 7. Failure to join a required party under Rule 19. Now, the waiver rules for these defenses are critical for exams. Never waived. Lack of SMJ, 12b1, can be raised at any time, even on appeal. Waived later. Failure to state a claim, 12b6. Failure to join a required party, 12b7. And failure to state a legal defense can be raised in any pleading by a later motion for judgment on the pleadings or even a trial. Waived if not first. This is the trap. Lack of BJ, 12b2, improper venue, 12b3, insufficient process, 12b4, and insufficient service of process, 12b5, are waived forever if the defendant files a Rule 12 motion but omits these defenses, or are if the defendant files an answer without including these defenses and didn't raise them in a prior motion. This is the omnibus motion rule from Rule 12G and H. You must consolidate these specific waivable defenses in your first Rule 12 response, motion or answer.
Wow, okay. That omnibus rule for PJ, venue, and service defenses is huge. You lose them if you don't raise them right away. What about the 12b6 motion to dismiss for failure to state a claim? How does the court look at that?
For a 12b6 motion, the court looks only at the face of the complaint and any documents attached or incorporated by reference. It assumes all the factual allegations in the complaint are true and draws all reasonable inferences in the plaintiff's favor. The question is whether, based only on those allegations, the plaintiff has stated a plausible claim for relief. The court doesn't consider evidence outside the pleadings at this stage. If it does, the motion might be converted to one for summary judgment. Other Rule 12 motions include a motion for judgment on the pleadings, 12C, after pleadings are closed, a motion for a more definite statement, 12E, if pleading is vague, and a motion to strike, 12, for insufficient defenses or redundant scandalous material.
Right. If the defendant doesn't file a motion or files one and it's denied, they have to file an answer, right? What goes in that?
Yes. The answer is the defendant's pleading that responds to the factual allegations of the complaint and asserts defenses. Under Rule 8b, the defendant must respond to each allegation by 1. Admitting it, 2. Denying it. General denials are rare, specific denials are preferred. 3. Stating that the defendant lacks knowledge or information sufficient to form a belief about the truth of the allegation, which acts as a denial. Failing to deny an allegation except for damages generally means it's deemed admitted. Crucially, under Rule 8c, the defendant must state any affirmative defenses in the answer. These are defenses that defeat the plaintiff's claim even if the allegations are true. For example, statute of limitations, assumption of risk, fraud, duress, contributory negligence. Failure to plead an affirmative defense generally results in it being waived. The deadlines to serve the answer are usually 21 days after service of the complaint, 60-90 days if service was waived, or 14 days after the court rules on a Rule 12 motion.
Affirmative defenses must be in the answer or they're waived. Got it. What's a reply?
A reply is the plaintiff's answer to a defendant's answer. It's generally only required if the defendant's answer contains a counterclaim, a claim by the defendant back against the plaintiff. In that case, the plaintiff must reply to the counterclaim allegations, just like a defendant answers a complaint. Otherwise, a reply is only allowed if the court orders one. If required, it's usually due within 21 days.
Can pleadings be changed after they're filed? Like if new facts come up or you made a mistake?
Yes. That's covered by amendments and supplemental pleadings under Rule 15. A party can amend their pleading once, as a matter of course, without court permission, within 21 days after serving it, or if the pleading requires response, within 21 days after the responsive pleading, or Rule 12b, E, or F motion is served, whichever is earlier. After that one free shot, or outside those time windows, a party can only amend with the opposing party's written consent, or with the court's leave. Rule 15a2 famously states that the court should freely give leave when justice so requires. Courts are generally liberal in granting leave unless there's undue delay, bad faith, repeated failure to cure deficiencies, undue prejudice to the opponent, or futility of the amendment.
Okay, amendments are usually allowed. What's this relation back doctrine? That sounds important maybe for statute of limitations problems.
It's extremely important for statute of limitations issues. The relation back doctrine under Rule 15c determines whether an amended pleading is treated as if it were filed on the date of the original pleading. This is crucial if the statute of limitations ran out after the original pleading was filed, but before the amendment. An amendment adding a new claim relates back to the original filing date if the new claim arises out of the same conduct, transaction, or occurrence set out or attempted to be set out in the original pleading. An amendment changing a party, or the naming of a party, against whom a claim is asserted is trickier. It relates back only if 1. It asserts a claim arising from the same conduct, transaction, or occurrence as the original pleading, and 2. Within the 90-day period for serving the original complaint, plus any extensions. The new party receives such notice of the action that they won't be prejudiced in defending on the merits. And 3, within that same period, the new party knew or should have known that the action would have been brought against them, but for a mistake concerning the proper party's identity. This mistake requirement is often strictly interpreted. Relation back for new parties is a frequently tested, complex area.
Same transaction, notice, and knew or should have known about the mistake. Got it. One last thing on pleadings, Rule 11. Signing implies something, right?
Yes, Rule 11 requires attorneys or unrepresented parties to sign every pleading, written motion, and other paper. That signature certifies that to the best of the person's knowledge, information, and belief formed after reasonable inquiry.
Wow.
1. It's